This is WPSL Port St. Lucie, the talk of the Treasure Coast.
The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Good morning, Treasure Coast and beyond. I hope everybody has had a nice week. It looks like it's actually going to be a nice weekend. We can enjoy that. It's not 10 degrees. It's not snowing. It's not 30 below zero. So we have a little something to be thankful for. I hope everybody had a nice Valentine's Day yesterday. Veronica, I have a question for you.
Mm-hmm.
Who can I sue
Oh,
if I didn't get any chocolate?
well,
I didn't get any chocolate. And I have a chocolate fix.
yeah.
Very, very,
You know what?
very, very upset.
Today, all those hearts are on sale.
Right. I may have to go.
You can
I may have to
treat
go
yourself.
get some for myself and my son. He wanted to know where the chocolate was as well.
Oh, he didn't get any either. Oh.
He got a couple things at school, but it all depends upon where one is standing in the relationship game.
Yeah.
It's a fun process.
I wouldn't worry about that. I wouldn't worry about the Valentine's Day thing.
Well,
Yeah.
it's funny. It was, I really did not plan on it. But you want to know something? I realized later on in the day,
here.
it was the first time in 20 years I hadn't been involved in a relationship.
You
on
felt
Valentine's
a
Day.
little gypped,
Well, not
little robbed,
gypped,
little
it was
robbed there.
I did want my chocolate.
Chocolate.
Anyway,
We do chocolate at Christmas. We don't do chocolate at Valentine's Day.
I guess there is nobody I can sue, huh? Well, in this country, you can sue anybody for
anything, yeah.
Doesn't mean you have to be right.
Yeah.
So, maybe I can come up with somebody.
Like the case about the kid who's, it's an adult child, trying to sue his parents because he didn't give consent to be born.
Yeah, I remember that one.
Minors can't really give consent, can they?
No, and not until
So
they're 18.
technically, yeah. Now, so what attorney would take this case, and what judge would hear it?
Well, an attorney who wants publicity,
Okay.
and a judge whose case it happens to land in before he dismisses it.
So I would be like, don't even bring this into my court.
Well, there are a lot of judges that say that.
Yeah, okay.
I've heard that said in courtrooms that I've been in.
I mean, here's the thing, stupid. You can't give consent if you're a minor. So now what's your problem? You still want to sue mom and dad?
I hate to be flippant, but if you're so unhappy about being born, there are ways to deal with it.
Hey, yeah. Right. Since you were 18, you had the keys to your destiny.
Yeah.
So.
All righty then. Now, I could say that we have a very special show today.
Awesome.
It is an emergency show.
Uh-oh.
The problem is it's an emergency of my own creation.
Oh, one of those.
So is that
No.
really an emergency?
Well, it depends, I guess.
That's just
What's going on?
That's just my little political.
This is WPSL Port St. Lucie, the talk of the Treasure Coast.
The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Good morning, Treasure Coast and beyond. I hope everybody has had a nice week. It looks like it's actually going to be a nice weekend. We can enjoy that. It's not 10 degrees. It's not snowing. It's not 30 below zero. So we have a little something to be thankful for. I hope everybody had a nice Valentine's Day yesterday. Veronica, I have a question for you.
Mm-hmm.
Who can I sue
Oh,
if I didn't get any chocolate?
well,
I didn't get any chocolate. And I have a chocolate fix.
Yeah.
Very, very.
You know what?
Very, very
Today, all those hearts are on sale.
Right. I may have to go.
You can
I may have to go
yourself.
get some for myself and my son. He wanted to know where the chocolate was as well.
Oh, he didn't get any either. Oh.
He got a couple things at school, but it all depends upon where one is standing in the relationship game.
Yeah.
It's a fun process.
I wouldn't worry about that. I wouldn't worry about the Valentine's Day thing.
Well,
Yeah.
it's funny. It was, I really did not plan on it. But you want to know something? I realized later on in the day,
Yeah.
it was the first time in 20 years I hadn't been involved in a relationship.
You
on
felt
Valentine's Day.
a little gypped,
Well, not
little robbed,
gypped,
little
it was
robbed there.
I did want my chocolate.
Chocolate.
Anyway,
We do chocolate at Christmas. We don't do chocolate at Valentine's Day.
I guess there is nobody I can sue, huh? Well, in this country, you can sue anybody for
anything. Yeah.
Doesn't mean you have to be right.
Yeah.
So, maybe I come up with somebody.
Like the case about the kid who's, it's an adult child, trying to sue his parents because he didn't give consent to be born.
Yeah, I remember that one.
Minors can't really give consent, can they?
No, and not until
So
they're 18.
technically, Now, so what attorney would take this case, and what judge would hear it?
Well, an attorney who wants publicity,
Okay.
and a judge whose case it happens to land in before he dismisses it.
So I would be like, don't even bring this into my court.
Well, there are a lot of judges that say that.
Yeah, okay.
I've heard that said in courtrooms that I've been in.
I mean, here's the thing, stupid. You can't give consent if you're a minor. So now what's your problem? You still want to sue mom and dad?
I hate to be flippant, but if you're so unhappy about being born, there are ways to deal with it.
Hey, yeah. Right. Since you were 18, you had the keys to your destiny.
Yeah.
So.
All righty then. Now, I could say that we have a very special show today.
Awesome.
It is an emergency show.
Uh-oh.
The problem is it's an emergency of my own creation.
Oh, one of those.
So is that really an emergency?
Well, it depends, I guess.
That's just
What's going on?
That's just my little political commentary.
Okay.
I mean, if I was lazy this morning and didn't prepare and declared an emergency, would it really be an emergency?
I see where you're going.
that may get some calls in. 340-1590. Is it an emergency if you create it? And for those of you who disagree about the creation prospect, and you all know what I'm talking about, hey, come in and call in an attack.
Creation, delusion, I'm not sure.
Insanity. All right, so let's get to the law. We were talking last week a little bit about some of the types of calls that we seem to get in the office on a fairly regular basis. And so we're going to continue in that vein with different types of calls and, hopefully give you folks some information that, areas where you may very well have a claim and you should call somebody, and areas where there may not really be a claim, even though maybe there should be a claim, maybe you think there's a claim, but under the law there just isn't a claim. So, again, call us on whatever I'm talking about or any other topic. Again, 340-1590. Last year at this very time, we had a special emergency show. It was about the Second Amendment and gun control and what the Second Amendment really intended when you go way, way back and look at the Federalist Papers and the things that were being said by the framers about the Second Amendment. And, of course, we had that show because a year ago yesterday was the Stoneman Douglas shooting, which is a horrible...
And what is it, like 20-some years from Columbine?
Yeah, something like
Not
that.
like
And
it.
we go through every other school shooting that can be... There's too many to remember anymore by memory. That's a pretty horrible way to spend a Valentine's Day, I'm sure. And I guess those parents and siblings and whomever will probably spend every Valentine's Day for the rest of their life more sad than happy. But that's a situation. We've had a few special shows that came into existence at the very last moment just because it seemed important. We talked about the Second Amendment. We talked once about insurance companies practicing medicine. Obviously, we had a special show after Senator McCain died. And there are things that come up that seem to merit discussion that interrelates with the law. And even if it may not directly relate to my practice, it seems to present a good topic for conversation. But we'll switch back to my practice now after these for commercial messages.
But that's why you're here, right?
All right.
Yeah.
So let's talk a little bit about wage and hour. People being paid and not getting their money, not getting all of their money.
Or thinking they're not getting all their money.
Having certain monies deducted that they don't think should be deducted. This happens all the time. It happens with surprising regularity, and with employers acting in ways that one would think an employer of any size would realize is just not appropriate. So, for example, we get phone calls, the simplest one, I haven't been paid. Okay, if you have not been paid for time which you worked, you have a potential claim. Now, it could be a small claims court claim. It could be a federal case under the Fair Labor Standards Act. It could be a breach of contract case. A lot depends upon exactly what is going on. And I see somebody just got Dunkin' Donuts, and I'm not getting any. Again, no chocolate for me. I'm just being persecuted here.
I didn't know if you were a coffee guy. You know what? We can arrange that for next week.
Okay. So if you haven't been paid, you should definitely be calling a lawyer and finding out what can be done about it. They didn't pay my overtime. Another very common phone call we get. That gets very complicated. We spent, I think, 2 weeks here on overtime law.
Well, quickly, what is? I mean, who
right.
who gets it? What
Very
is?
quickly, okay?
Why do you think you get it?
If you are non-exempt, and we'll discuss that in just a moment, non-exempt, then you are entitled to time and a half for all hours over 40 in any week. It's as simple as that. Now, what complicates the matter is if you're non-exempt. We start out with the premise that everybody is non-exempt. But then there are about 100 exemptions or more. 3 or 4 big ones, but there's a lot more of them. The primary exemptions. If you supervise 2 or more people, earn a certain salary, have decision-making authority, you're probably going to be exempt. Managerial exemption, administrative exemption. If you're a lawyer, professional exemption. If you're a doctor, professional exemption. If you do outside sales, there's an exemption for that. So there are lots of exemptions.
Yeah, well, you wouldn't want your doctor to want to punch out like in the middle of a really long surgery.
No, I need time and a half to finish the surgery.
Yeah, I'm out of here.
There's a good reason for that exemption.
Yeah.
But we start out with the premise that the average person is probably entitled to be paid overtime for time and a half.
So back way a long time ago when I worked for the really big radio company and they told me, you're middle management, I need you to finish this, I don't care how long it takes, and you worked every single day, 12 hours a day, nonstop, blah, 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 with no overtime. But not the head of the department, had a title, but had no...
Titles are irrelevant.
Had no ability to choose anything for my department, but get this done, no, you're not getting paid extra.
Veronica brings up a very good point. Titles are irrelevant. Totally and completely irrelevant.
And it was, you don't get overtime, you're middle management.
Right, and there is no such exemption.
Okay.
What matters is...
I got robbed.
Right, yeah, you probably did. Unless there's a radio exemption. I'd actually have to look.
Oh, well, maybe.
Maybe. Telecommunications exemption. I don't know.
Yeah.
But you bring up a point. The titles are irrelevant. People call, I'm a manager. Does that mean I'm exempt? No, not really.
Well, somebody might tell you that, though.
Exactly. If you're a manager and you do not supervise 2 or more people, if you do not make at least a salary of $455 a week, if you do not exercise discretion with regard to matters of significance, and if you do not have at least input into hiring or firing, you're not exempt, which means you're entitled to overtime.
Right.
Doesn't matter what the employer classified you as, and that's where people call into the misclassification lawsuit, or possibly a lawsuit if a demand letter doesn't work. So when we get these calls about, I didn't get paid overtime, the first thing that we do is try to find out, well, what is it that you do?
Mm-hmm.
Tell us your duties, tell us your responsibilities, what is your authority, do you supervise anybody, do you run a subsection of the business, do you run the bookkeeping department? You may have an administrative exemption if you run a department,
Mm-hmm.
okay? And when we get the preliminary information, when typically Cheryl gets the preliminary information, we are able, when she comes to me, to make an initial assessment as to whether, okay, Cheryl, go call this person and ask these additional 3 questions. Or, depending upon the case, why don't we pick up, let's call them right now. Or, suggest they come in, overtime is typically a free consult, okay? Wages are typically a free consult. I may have heard enough, I don't have all the answers, but I may have heard enough to say to me, it seems like something is here.
Mm-hmm.
So let's bring them on in, or let's offer for them to come on in. But that's really, when we get that information, we have to analyze it and try to figure out, does an exemption apply? And that is sometimes very difficult. It is sometimes a close question. That doesn't mean it's not worth a demand letter. That doesn't mean it's not worth trying to squeeze your employer or your former employer, typically. A lot of people don't like to make waves about overtime while they're working, and I understand that.
Yeah, well, that's not going to last long.
But you only have 2 years to go back, 3 years if the employer's failure to pay is willful, and that's a whole other legal standard. So if you've been there for 15 years and haven't been getting overtime and haven't been complaining about it because you didn't want to rock the boat, well, you've lost probably 12 years of overtime. So at some point, everybody has to make a decision. How bad is this, and is it worth it? Because, again, nobody can protect you completely. We realize that. But if you do complain about not getting overtime, or even inquire about whether you're entitled to overtime, and you're punished, that violates another section of the statute. It's an anti-retaliation provision. And so let's say you're not entitled to overtime at all, but you're fired for bringing it up. You have a retaliation lawsuit. If it takes you 2 months to get another job, and your other job pays you $3 an hour less, you may have a substantial case. So I do understand the concern about making waves about certain things while you're still employed. Sometimes it's necessary, but that's a very personal call. And sometimes people will call us and give us a fact scenario. I can't say to you, you should do this. I can say legally you should do this, but I can't step into your shoes and tell you should do it. I can only give you the information and let you weigh your own cost-benefit analysis, recognizing that there are forms of retaliation that are subtle, that might not really be provable, or might be very difficult to prove.
Or may happen 6 months to a year down the road.
That's correct. But and the longer it takes...
But you're walking around with a target on your back the whole time.
And the longer it takes, the less likely it is that you're going to prove causation. Typically under the law, most statutes say, if something happens at least within 30 days, there is a presumption that it's connected. Now, the employer may be able to disprove it and show really it was completely separate, but there is a presumption. There's an inference, okay? And lawyers like inferences and presumptions. It helps go a long way to, the burden of proof. Now, we get calls with sticking on wage and hour. They didn't pay me for training. That's a really interesting question. If the training is mandated by the employer, you're to be paid. So if you weren't paid, you have a right to complain. If that training put you over 40 hours, you may also be entitled to overtime. They make us come in once a month for a staff meeting. Off the books, off the clock. No. If that is required as a condition of employment, you are obligated, you're entitled to be paid. Same thing. And if it puts you over 40, you're entitled to time and a half for those hours.
What if they have it at a restaurant and feed you?
Doesn't matter.
Okay.
If it's mandated by the employer.
Okay.
If it's a condition of employment. Now, if you are applying for a position and you're told, well, we're going to send you for some training, but you're not yet an employee, no, they don't have to pay you. That's a deal you make pre-employment. But for the most part, there are, again, in the law and everything, there's always an exception. Sometimes lawyers get paid to find the exceptions that either help their client or protect their client from filing a lawsuit that's just going to be a waste of time. But for the most part, if you're required to attend a training, a staff meeting, you should be paid, even if you're fed. Okay? Especially if you're fed bad food. And what other food does the employer typically feed you? Okay, so now they didn't pay me for training, they don't pay me for meetings. So we just discussed that. The two go hand in hand. They don't pay me for lunches when I have to work. Well, you're entitled to be paid. Now, the rule here is very, very specialized, and it's very beneficial to the employee. There aren't a lot of statutes which are employee favored. This is one of them, Fair Labor Standards Act. And I've told my own paralegal this, Cheryl knows, and thank goodness I rarely do it, and Cheryl has not used it against me in a court of law. Thank you, Cheryl. But if, let's say she's decided to have an hour lunch in the office, and she closes her door, and, she's having lunch. And because she is near to me, and something comes up,
or the phone rings,
and I can't restrain myself, and I go, Cheryl! And she says, what? I say, I need. Okay. Takes her 5 minutes. Do I pay her for 5 minutes? No. I pay her for an hour. Once you interrupt the employee's lunch break for anything, you're now obligated to pay that entire lunch period. And so if this happens 2, 3, 4, 5 times a week, and the employer is not paying you for lunch, even though you're being interrupted, you have a claim. And it's one of the reasons why attorneys that represent employers, and I've only done it a few times, mostly I'm almost always representing the employee, but I have had a couple employers that have been my clients. My advice, tell them they have to leave the office for lunch. Get them out of sight, out of mind. Don't yield to the temptation that you're going to ask them to do something.
So if you work in a place where you punch a time card, and you're working
Right.
9 to 5, it's all day.
9 to 5, going to make a living. But
Yeah.
I can't sing like Dolly Parton.
Do you? Okay, let's just say you're punching. You punch out for lunch and you punch back in after lunch.
Right.
That's not a paid lunch.
Right.
Okay.
No. If you've left and you've been left
But if
alone,
you punch out and then
you're asked before
to
you walk out the door, Cheryl, can you come in here for a second?
Okay.
That lunch hour is compensable now. Now, let's say it's you're like you say, it's a time clock, so you don't punch in for 2 minutes
and punch back out.
The point is, at some point, if depending upon your relationship with the employer or your supervisor, you bring it to their attention, and there needs to be a manual adjustment because you're not going to punch back in and then not punch out again. Somebody's going to be yelling and screaming, I guarantee it.
And quit asking me stuff on my lunch break.
But that also goes to another point. Employees, keep track of your own time. Don't rely upon the fact the employer has the records, because then when you come to see me, you don't know anything. Or you can't prove anything, because I can't get the records from the employer until there's a lawsuit, and so it's hard to figure out what you may be entitled to. I've had clients come in with these calendars that have the time they worked every day just in a corner, and they've been keeping track. And so that's good also as a practical reason for, you see that you worked 37.6 hours. So we're not even talking overtime. 37.6 hours. And you get your paycheck for 35.2. Well, I would think that would lead you to ask a question. Now, this is not unusual. This is not something that employers will typically fire you for. There are some, sure. But I remember when I was just a babe, starting my work life, back, now, I hate to say,
a long time ago.
43, 44 years ago. My first job. I remember when I worked in a home center. They didn't have Home Depot and Lowe's back then. Yeah. But routinely, I'd get a paycheck, and it was off by a little bit here or there. And always I go to my man, why is this? Oh, well, let me look into it. And sometimes it was a good answer, sometimes it was just fixed. I don't know why those mistakes happen. They shouldn't, but they do. And so if you're keeping track of your own time, you're better able to make sure you're being paid because, let's be honest, even if you love your job, you're working for a paycheck.
The whole reason why you go there.
Unless you're independently wealthy, and you don't need it and you're just working for the fun of it. But 99.9% of us, 99 because we all know about the 1%, really do need a paycheck.
Well, somebody along the way somewhere worked hard to get something.
And fortunately, if we're doing something we love, that's great, but we still want to get paid.
Mm-hmm.
Okay, and so it's good to keep track of your own time. And once again, folks, it's 340-1590. Give us a call and ask me a question, yell at me, complain. I don't know, whatever you want to do.
My first job was at Kmart in suburban Chicago, and you would punch in, and everybody would gather around the time clock because you had to punch in that minute, because if it clicked over to 1 minute, you were losing 15.
That's right, exactly.
And
that's not allowed either.
Yeah, and they would take your time card and they would make the little notes on it, and you would get every week a pay packet with actual cash, with your time cards stapled to it.
Oh, so it was under the table.
No, well, no.
Cash?
They paid cash.
Somebody's trying to avoid taxes.
Well, it was all there on your. It was all figured out.
Really?
Yeah. But the whole concept for Kmart and the cash was that you'd leave some in the store on your way out on payday.
What a smart psychology.
But you see where they are today, though.
I see where they all are. And of course, in my first job, as it turns out, I did get cheated. So maybe that's why I'm doing wage and hour law. My first job was at a local pizza place. Surprise, surprise. I did something.
I have to ask you, in Jersey?
In Jersey.
Okay.
And I did something I hated the idea of doing. I've never done since. I hate doing at home. But to get my first job at a pizza place, I was willing to do it. I worked in the back cleaning dishes.
Yeah, that's what I thought.
Disgusting.
That's where everyone starts.
Disgusting. But as a perk, I was allowed to have pizza every night for dinner.
I think that's a great perk.
It was a wonderful perk. Now, back then, pizza was like 50 cents a slice or 45 cents a slice.
I would work for pizza.
So would I. But I got paid too. And I show up one day, it's like pay every 2 weeks. And I show up one day for work, and the pizza place is closed. So I figured, okay, maybe somebody's ill or something. I go back again. It's closed. And I start asking questions in the little strip mall where I lived. I said, they moved out. They ran away and didn't pay me for 2 weeks.
Oh.
And there was no way to figure it out, and
they just locked the door and boogie.
Yeah, so I lost 2 weeks of pay for cleaning dishes. I'm sure everybody out there is going, what can I tell you? All right, so you keep track of your time. What about you work from home?
Yeah, how does that work? Because that sounds intriguing to me.
Well, I have a couple lawsuits on that right now.
Okay.
How does that work? It works very complicatedly,
okay,
if that's a word.
I mean, you could work at home because it's your practice. Right. I mean, that works out.
But if you have an employee who's being paid, let's say you have a time clock. Well, you certainly don't have it at home.
Right.
Let's say there's software that you clock in the office by accessing the software. Well, you don't have that at home either, usually. So what happens about work at home? Well, it's compensable. And you should be making a note of it, and you should be going in the next day or at least at the end of the week with, a printout or a list or whatever you've created and giving it to your supervisor and having it input so that you're compensated for it. Because if you're asked to work at home, it's compensable. And if you do work at home without being asked, it's still compensable. Now, they could fire you for it if they didn't authorize it. They could fire you for working overtime in the office if they didn't authorize it. But that first time, it's like one free bite. They got to pay for it. If you worked it, you're entitled to be paid for it.
Mm-hmm.
If it wasn't authorized, they can do whatever they want to.
Sure, it should be a let's don't let this happen again.
Yeah.
Mm-hmm.
But it's working from home, a lot of employers allow that. Some of them will have a better mechanism than others to keep track, to allow you, the employee, to keep track, and the employer to maintain records. And let's not forget something. Under the Fair Labor Standards Act, the burden, statutory burden, is on the employer to maintain complete and accurate time records. Those are the words in the statute. Those are the buzzwords. You screw up as an employee, it's the employer's fault. Their burden to keep complete and accurate time records. So this is typically what happens in a wage and hour suit or an overtime suit. Well, I didn't keep track of my calendar, but over the last 2 years, on average, I think I worked about 10 hours a week overtime. Normally, that's not really good evidence. In a wage and hour case, it's pretty good evidence. Because now, the employer has to rebut that. And since it had the statutory burden to maintain complete and accurate time records, it's going to have a really hard time. And then the jury is instructed that if the employer failed to maintain its obligation to keep complete and accurate time records, that unless for whatever reason the jury finds the plaintiff's testimony lacks credibility, you are to accept as true the testimony of the plaintiff, here 10 hours, and calculate it. And so even without your backup, there's a lot of room for, unfortunately, exaggeration, but if the employer is not keeping those records, the employer is running a very big risk. And so if you're working at home, which, for example, I have a client who does, home health care. At home, at the end of a day, they're required to prepare reports and then input them and upload them, to the employer's system.
I've seen that. I've had, elderly people with,
Right.
when they come though, they use their phones
Right,
now,
yes.
and they make a phone call, which is, I guess, into like
A system.
when I've started with this
Exactly.
patient.
So now you're home doing the required reports at the end of the day, you're entitled to be paid. Now, a good employer is going to have a mechanism for you to keep track of that, because the employer should want to keep track of it because of its duty, and also just, to be fair about it, if it doesn't want to be taken advantage of by an unscrupulous employer or somebody it fires, it better have complete and accurate time records. And so the incentive is to give you a mechanism where you can accurately keep track of what you're doing at home. If the employer doesn't do that, and you either submit 1 week 7 hours, and they cut it to 5, well, I'm glad you have records of 7 because you're entitled to those extra 2, unless they can prove you didn't really work it. Okay? And there's lots of ways to prove these things now these days. All right, for example, like you mentioned, a phone. If you go to client A's house and call in, well, there's going to be a record that you called in at 9:33. Now, there may be no record as to what was said, but there'll be a record that you called in at 9:33. There'll be a record that you called in at 10:12. Presumably, that's when you left. There'll be a record for the second client. You got there at 10:42. The rest is travel time. That travel time is compensable because it's travel from one site to another site, not commuting.
Sure, and I'm sure that your professional time with the patient is this, and your travel time is something else.
No.
No? Would you get paid for
You get
for
paid the
travel?
same thing.
Really?
Yep, there's no specialty on travel time.
So when you're driving, you're kind of like on the clock
It's
still?
wonderful, isn't it?
Oh, I would think that it's like we're only keeping track while you're actually working with a patient.
No, if you're driving from point A to point B to get from one job location to another job location, that is compensable time.
Wow.
Now, at the end of the day, let's say, you're required to drive from wherever your last appointment is back to the office. That is not compensable time.
So the call-in probably is in order to bill that patient for the time.
Yes.
Okay.
But it helps keep track of the fact that when you got there,
and
when
we
you
know
left.
where you were all day.
Right.
Yeah.
What if, I have clients, I have one right now. Well, I worked at home only because I'd get text messages and I'd get phone calls and they'd be asking me questions and they'd ask me to do something. How are you keeping track of that? Well, you should try. You should, okay, I was on the phone for 10 minutes. Make a note of it. and try to get compensated for it for the next pay period. If you have a problem, just continue to keep track of it, because one day you may want to do something about it.
Mm-hmm.
Okay? Well, how do you prove it? Well, you may never be able to prove the exact number. But then again, remember, the employer is the one with the burden. And if you can give credible testimony, a jury is going to be told it should believe it. So if there's a text message from your supervisor, I need to know how to contact Bill Smith, that's great evidence that you were asked to do some work at home. And then you respond, and they respond. And now you're keeping a great record of you're being forced to work at home. So if you don't have something for, an instance, 1 week, there's still a good likelihood a jury's going to believe you, because you're able to show a pattern of this happens on a regular basis.
Mm-hmm.
We have John on line 1. Hello, John. How are you?
Good morning. I have 2 questions. I hope I can slip them both in.
You
The
can
first
slip
one
them
will be
both
brief.
in.
Thank you. I'm not married. I buy a home. I get a mortgage in my name. The title's in my name. A month later, I get married. Should I have to call the mortgage company to see if I can quit claim my wife onto the property?
I wouldn't. I actually had the same factual scenario. I bought a home, got married a few months later, and no, I didn't, because by not putting the wife on the deed, that becomes your separate property pre-marriage. And God forbid you ever get divorced, your spouse has no claim on that property, again, with exceptions. If they can show they were assisting in the upkeep and mortgage payments, there may be some claim, but it's not going to be the standard they're entitled to 50% of the value of the house. Once you put your spouse, husband or wife, on a deed, they are now owners. They are now entitled to 50%. God forbid something goes wrong with the marriage. So
Sure.
From a practical sense, I would say no, don't do it.
Well, I love my wife, and we're gonna have a child, so I want her, to have security.
Could you just do a trust and have her be the beneficiary? Wouldn't she automatically
Now you're getting
be...
into areas of law that I'm not the greatest at, but yes, you can.
Well, yeah.
You can do a trust. There are other things you can do as well to make sure she's protected, without necessarily, having her have an entitlement to 50% of the real property. But
I guess my main question was, I'm not so concerned at my age about my wife, getting all my assets. I guess my main concern is, if I get a mortgage, do I have to notify my mortgage company?
They would.
Well,
if you're changing the title, wouldn't?
No.
No?
You can put somebody on the title, and the legal obligation to make payments could remain solely yours.
So they don't care?
No, they don't really care as long as you make the payments. If you don't make the payments, they will move to foreclose. Even if she's on the title, she has no defense to a foreclosure action if the mortgage hasn't been paid.
By changing title,
so the quit claim is not an issue then.
No, not really. Not unless you want to make sure she actually has an interest in the deed.
Can it change your homestead though? Could it? Because sometimes you have a homestead from this year.
Right.
Wouldn't that make all the paperwork new, and wouldn't that be then recalculated?
Just because you're married?
Because you changed title.
Well, if you change title, you probably have to resubmit that for the homestead exemption, but it shouldn't change the entitlement to the homestead exemption.
Okay.
Yeah, as long as one person's lived there
Right.
December 31st, that person can claim the homestead.
Precisely.
Yeah. Now, the second question I have is, a friend of mine is married, and her husband inherited a house from the mother, and there was 2 other siblings. So there's 3 siblings that inherited the house. Now, one of them wants to live there. Doesn't want to give up doesn't want to pay them off. I guess they can do a partition. But the question is, my friend, who's not part of the family, only by marriage, is going through a difficult time. And if they ever got divorced, how does she get her interest from that will if it's never been actually executed, meaning the sale of the house?
Okay, I'm a little confused, so let me summarize, and you can tell me if I have it wrong. A certain number of siblings either have received or are going to get, when somebody passes away, interest in a house. They got it already.
Yeah.
Okay.
It was in the will. I leave it to my
Okay.
3 children.
All right. Even if the will has not gone through probate, right?
No, it's gone through probate.
Okay.
It's already been probated.
All right. So the people who now own the home, they own it as what's called tenants in common.
Yes.
You're right about the possibility of a partition action if it push comes to shove. Any one of the 3 of them, or 4 of them, or 5 of them, whatever, can file a lawsuit for partition to force the sale of the home and have the proceeds divvied up in an appropriate way. Now, we start out with the appropriate way being, let's say, 1/3, 1/3, 1/3. But if somebody decided, one of the 3, I'm going to live here and I'm going to keep up mortgage payments, then they're going to get a disproportionate share. The court will look at it and say, okay, instead of 33%, given what you've put into the property, maybe you're entitled to 45%, and then the other 55% will be split in half between the other 2. But so that's a partition action. And if the 3 people, let's say, who are given the property cannot get along, and I've seen this too, I've dealt with this too, then unless they can come to an agreement, it's a partition action. That's the way to get it resolved.
Yes. But the biggest issue here is my friend is not part of the family, only by marriage.
Right.
And they might be going through a divorce. So the reason why they don't want to sell the house is so that she doesn't get any marital assets that have been in a will.
Okay.
So if they get divorced tomorrow and then they sell the house next week, is my friend out of her interest in that will?
I don't think so, because we're not really dealing with the will anymore. The will is over with.
Okay.
We have a
So
house. We have a house. Let's say.
Now, is that spouse technically entitled to anything from that other person's inheritance?
Well,
Sure, she is.
Yes,
It's like a
Inheritance
lottery.
yes.
If your husband wins a lottery,
Okay, but they don't have it
he
yet.
hides the ticket. Well,
no,
if your
they do
husband
have it
wins
yet.
a lottery,
They do have it yet.
yeah, they do have it.
Let's say the three children receive the house.
Yes.
They're now the 3 children are tenants in common. One child is married.
One's living in it. Yes.
Okay, and regardless, one child is married.
Yes.
The wife who is married into the 3 kids, only married one of them, of course, but the wife who is married into this group, if she is going to get divorced, the question is, how does she get any interest in this? Well,
Why should she, is my point.
well, I'm sorry. The interest of her husband was acquired during the course of the marriage. Therefore, his interest is marital property.
Can he forfeit it to his siblings?
He could try, but it's not going to work.
Okay.
Okay?
Because it's in the will. The mother put it in the will, so you can try finagling, but it's not going to work because the judge is going to see that he left.
Right, and there's other ways to prove
it.
that too. But no, I would say that it becomes marital property, and so she's going to make a claim on that. You know, when you file for dissolution, you all got to fill out all these extensive, forms for assets and property. And if I'm in her position, I put it down as a contingent interest in this property.
Yes, thank you.
1/2 of his 1/3 interest. So if my fractions are right, a 1/6 interest.
Minus the 3% that the executor of the will can charge.
Oh, minus all sorts of things. All right. Well, I hope I helped you, John.
You did. Thank you very
You're
much.
very welcome.
The woman is tough here. Are you aware?
I know. No,
I know. She's my producer, and she's
women are supposed to stick up for other women.
They
I'm
never
surprised
do.
here.
They never do.
That's why sometimes you don't want them on a jury when you represent defending a woman.
Thank you.
Take care. We have Carl on line 2. Hello, Carl.
Now hang on for Carl.
All right.
There we go. That button's
Carl,
very hard to
are
push.
you there?
I'm here.
How are you?
I'm fantastic.
How
are you?
I'm doing all right. How can I help you?
I came into the show a little late, and you were talking about employees, and I didn't know if you mentioned anything about salaried employees and what rights they have.
Yes, we've talked about that a little this morning. We talked about that a lot over the course of a couple weeks over the last year, but I'm happy to answer any question you have.
Well, it was just hourly. What do you? I never knew what an employer would expect out of a salaried employee. So is I cut off at 40 hours or?
No. If you are legitimately exempt from overtime under the Fair Labor Standards Act, then you can be paid a salary. Okay. Now, a lot of employers will pay you a salary and say you're a salaried employee, therefore you're exempt from overtime. That's wrong. You're only exempt if you're in a position that qualifies you to be exempt. So getting a salary doesn't necessarily answer the question. But let's assume you're truly an exempt employee. You're a manager of some kind. You supervise 2 employees. You make at least $455 a week as a salary. You have some discretion you're allowed to exercise. Let's say you fall within one of the exemptions. And you're paid whatever you're paid a week, $1 million a week is your salary. For that $1 million, the employer has the right to expect you to do everything necessary to complete the tasks that you're assigned.
No matter if it's 8 hours or 10 hours
That's
or
right.
12 hours that day.
And if you're paid $455 a week, the minimum for a salary and to be properly exempt, and it takes 80 hours to do the job, your obligation is to do the 80 hours and not get paid a penny over the salary. That is, there are benefits to being a salaried employee, a properly salaried employee, and there are drawbacks to being a properly salaried employee. The biggest one is not getting overtime. But if you're properly salaried, let's say you need to take off half the day for a doctor's appointment, they can't dock you. If you're properly a salaried employee, the employer can only dock you in full day increments. So unless you take a full day off, they have to accept it. And why do they have to accept it? It's a very rational reason. Because your obligation is to do all the work that you need to do and get it complete. If you take a half day off, but you still satisfy that responsibility, it's not really the employer's business, how you accomplished it. So salaried employees have a separate set of obligations and rights than hourly employees. The problem that I encounter in my practice is where employers try to make an hourly employee salaried so that they think they're not entitled to overtime. And also, we haven't discussed this today, but they try to make an employee an independent contractor so they don't have to pay the Social Security and Medicare tax.
Or insurance, any benefits.
Right. And well, the benefits are one thing, but Social Security and Medicare is the big thing that they try to avoid because it's 7.65% they save. And very often, these people that are called independent contractors, I have found, they're employees.
And what happens to that person if they are hurt at that job?
Well, then we have a fight over whether they were an employee or an independent contractor. Then
Okay.
they go to the gentleman who was on just a couple weeks ago. They go to Andy Reich at Reich and Mancini, and we deal a workers' compensation claim, and the employer defends that they're an independent contractor, and then Andy calls me, and we file a declaratory judgment action. But that's not what Carl was asking about.
Right.
No.
Did I answer your question, or do you still have something you want me to answer?
No, it's my thing was basically hours, and you
Right.
answered that. If
All
it
right.
takes 80 hours to do the job, then
That's right.
That's what you got to do.
As you move further up the ladder and you're properly exempt and you're getting a salary, you do the job you need to do, and if you do it well, I guess you get rewarded.
Well, and I look at another thing here, like I'll be working on a holiday, Monday.
Right.
Where, okay, I consider that time and a half if I was an hourly employee.
It's not.
It's not. Okay.
No, holidays do not become time and a half. Time and a half is for over 40 hours. Holidays, if they're holidays that your employer has determined it's going to be a paid holiday, it's regular time.
But that's more like company policy.
Company
then.
policy.
Okay.
Yeah, there's no law that says you have to be paid for a holiday.
Well, that's just say. Well, I figured. Well, I'm going to take a half a day off.
Right.
Because I worked on a holiday, and I'm figuring time and a half, not double time.
Don't figure it that way.
And then
You'll be surprised.
I worked that, but everybody else is off in the company, but me.
Right.
So.
All right. Well, thank you for calling, Carl. I appreciate it. Hope you enjoy the show.
Yeah, I do.
Take care. Bye. All right. So that's also very important, and trying to sort of in the little time we have, at least get through the wage and hour stuff. We get calls. I was told not to submit my overtime. Don't do it or you'll get fired. Or don't do it. Mm-hmm. And so you don't do it.
Or they just say, we don't pay.
Right.
We
so
just don't pay.
You don't want to lose your job, and so you don't do it. Mm-hmm. I understand. Hopefully you're not there more than 3 years. keep track of it. And then when they let you go, bang!
Mm-hmm.
Got a claim for the overtime. Okay? I'm being serious. You know, if you're there longer and it's worth it to you, then okay, you're going to lose a little bit every day. But, you know, a lot of employees, once they're let go, that's when they call and say, I want to go after the employer, and there is nothing wrong with that. There's also nothing wrong with trying to get what you're entitled to while you're still employed, and having a reasonable expectation under the law that you're not going to be punished for it. So what if we talked actually about the independent contractor issue as a result of this last phone call. You work overtime, but you're a 1099 independent contractor, and you're not really so sure if that's right or not. Well, you call a lawyer. Ask a lawyer. Because there are IRS factors, there's the Department of Labor factors, there's 11th Circuit Court of Appeals factors. They're mostly similar, but some of them are a little bit different, that help us to figure out, on balance, is somebody an independent contractor or are they an employee? So you're called an independent contractor because the employer doesn't want to pay those pesky Medicare and Social Security taxes.
Mm-hmm.
But
they want you to keep doing the job that you've been doing.
But let's say you're not. Let's say you're not really an independent contractor and you get hurt on the job. Well, if a lawyer helps you figure out that you're really an employee, then somebody like Andy Reich is going to file a workers' comp claim on your behalf. And the employer can fight it, but together with your workers' comp attorney and perhaps an attorney like me, we'll fight that battle, and then the workers' comp attorney will continue to fight the workers' comp claim. So don't just assume you're not entitled to overtime or any of these other things just because you're an independent contractor. If you think there's something funny about you being an independent contractor, then you call a lawyer.
I would think if you were an independent contractor, really, you would know that because that's how you would represent yourself.
You probably would know that because you'd be free to take on other work.
Mm-hmm.
For the most part, you'd be using your own tools. You'd have
setting your own hours.
You'd have control of setting your own hours, determining how the work is to be done. You'd have all sorts of more autonomy than if you're an employee. So a lot of times people do realize there's something wrong with me being called an independent contractor. And, they don't make an issue of it until it becomes an issue. But every week you're losing 7.65% of your income because the employer is not paying the matching share of Social Security and Medicare.
And that's why you're an independent contractor.
And that is often why you're an independent contractor. All right. What if you're leaving your job and they won't pay you your accrued PTO time, personal time off, paid time off, vacation, whatever they're going to call it?
Okay, so they say you didn't take it, you don't get it?
That's right.
Okay.
You lose it. There actually is law on that. It's not law that says you're entitled to it, and it's not law that says you're not entitled to it.
One of those.
It's law that says it's a matter of company policy. But the company must treat everybody the same. So if the policy is if you quit, you don't get it, and they do that with everybody who quits, then you don't get it. And the policy is if we let you go, you do get it, then everybody they let go better get it. They better not say no to you because they don't like what you did that caused them to let you go. Mm-hmm. If the company policy is we terminate you, we'll pay your PTO time, then if they don't pay you when they paid everybody else, you have a claim. So, PTO time is a matter of company policy. But you have to be treated fairly like everybody else, whatever that policy is. Well, and the policy isn't always in writing. The policy is very often just known. It's understood because you see people get fired, you see people quit, and this people got their PTO, this person didn't. Whatever the policy really is, whether it's on a piece of paper or just reality, that's the policy. So it's something to look at. What about, here's something that's all connected, and it could be our last little topic. You were hired a couple months ago, and they're not giving you what you promised. They promised. Whether it's the job title or the responsibilities or the wage. Well, you may have a breach of contract claim. Because if they're not giving you what they promised, it's an oral contract, but it's a contract. Okay. What if you moved here? I've had this too many times to count, especially here in Florida. You moved here from my good old home state of New Jersey, and you quit your job, and you sold your house, and you went through all the expense of moving here, and then you got another house, let's say it's a rental for now, and y'all did that because you got this wonderful opportunity, and you show up and they say, oh, I'm sorry, it's not available. Wow. Okay. You don't have a claim under the Fair Labor Standards Act. You don't have entitlement to wages. What you have is, and remember, you're an at-will employee. So let's say you showed up and they gave you the job. They could have fired you the next day.
Mm-hmm.
It's a risk you took.
Mm-hmm.
Not having a
I know someone who did
not
that.
having
2
a
months.
contract of employment.
2 months
Right,
and
okay.
gone. Mm-hmm.
You do have a breach of contract claim, probably for all the losses associated with you coming down here. What you probably don't have is a wage claim, because being an at-will employee meant you did all this knowing that you could be fired a minute into your job. So if you're going to do something like that, usually it's a higher level job, you should have a contract. You should have something that spells out what if. Otherwise, you're the one taking all the risk, and the employer's taking nothing, just waiting for you to get here. What about the last thing before we sort of tie down? They say, oh, you got to repay the moving expenses because you quit. Well, if they paid your moving expenses to get down here, and you're the one that quit, it doesn't mean you have to pay them back. Again, it depends upon your contract, if there is one, and it depends upon policy. But otherwise, there's no other obligation for you to pay them back. All right. So at least that's the wage and hour part of it. Hope you all have a very nice weekend. Hope it's warm and pleasant and fun. And next week, we'll be back at Friday at 10:05 for another edition of Ask a Lawyer. Until then, this is Stuart Address. My office number is 781-8003, and Cheryl is standing by waiting for your call. Have a great weekend, folks. Bye-bye.
This is WPSL Port St. Lucie, the talk of the Treasure Coast. This is WPSL Port St. Lucie, the talk of the Treasure Coast.
The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Good morning, Treasure Coast and beyond. I hope everybody has had a nice week. It looks like it's actually going to be a nice weekend. We can enjoy that. It's not 10 degrees. It's not snowing. It's not 30 below zero. So we have a little something to be thankful for. I hope everybody had a nice Valentine's Day yesterday. Veronica, I have a question for you.
Mm-hmm.
Who can I sue
Oh,
if I didn't get any chocolate?
well,
I didn't get any chocolate. And I have a chocolate fix.
yeah.
Very, very,
You know what?
very, very
Today, all those hearts are on sale.
Right. I may have to go.
You can
I may have to
treat
go
yourself.
get some for myself and my son. He wanted to know where the chocolate was as well.
Oh, he didn't get any either. Oh.
He got a couple things at school, but it all depends upon where one is standing in the relationship game.
Yeah.
It's a fun process.
I wouldn't worry about that. I wouldn't worry about the Valentine's Day thing.
Well,
Yeah.
it's funny. It was, I really did not plan on it. But you want to know something? I realized later on in the day,
Yeah.
it was the first time in 20 years I hadn't been involved in a relationship.
You
on
felt
Valentine's Day.
a little gypped,
Well, not
little robbed,
gypped,
little
it's like,
robbed there.
I did want my chocolate.
Chocolate.
Anyway,
We do chocolate at Christmas. We don't do chocolate at Valentine's Day.
I guess there is nobody I can sue, huh? Well, in this country, you can sue anybody for anything.
Yeah.
Doesn't mean you have to be right.
Yeah.
So, maybe I come up with somebody.
Like the case about the kid who's, it's an adult child, trying to sue his parents because he didn't give consent to be born.
Yeah, I remember that one.
Minors can't really give consent, can they?
No, and not until
so
they're 18.
So technically, yeah. Now, so what attorney would take this case, and what judge would hear it?
Well, an attorney who wants publicity.
Okay.
And a judge whose case it happens to land in before he dismisses it.
So I would be like, don't even bring this into my court.
Well, there are a lot of judges that say that.
Yeah, okay.
I've heard that said in courtrooms that I've been in.
I mean, here's the thing, stupid. You can't give consent if you're a minor. So now what's your problem? You still want to sue mom and dad?
I hate to be flippant, but if you're so unhappy about being born, there are ways to deal with it.
Hey, yeah. Right. Since you were 18, you had the keys to your destiny.
Yeah.
So.
All righty then. Now, I could say that we have a very special show today.
Awesome.
It is an emergency show.
Uh-oh.
The problem is it's an emergency of my own creation.
Oh, one of those.
So is that really an emergency?
Well, it depends, I guess.
That's just
what's going on?
That's just my little